some of these, you look at all of these different things, and do I need all these? Well, there's different aspects to a liability policy. You can't take out coverages that you don't like or that you don't think you'll need. It all comes as part of your general liability. But the USRowing policy does have $2 million per occurrence and a $6 million aggregate. And that's per each of your clubs. So, the limits are pretty robust. We have a few clubs that need higher limits than that, and we can offer those. We can talk about that later. There's also the excess medical coverage. This is for your championship members, the kids that pay $45 or the adults that pay $65. This is a medical policy which sits over your primary medical policy. So if you have any out-of-pocket expenses from a rowing-related injury, this policy will pick up your out-of-pocket expenses minus a $250 deductible. In this day and age, we have a lot of people that have high deductible insurance plans with their employer. So you may have a $3,000 deductible like I have. This policy will pick up everything up to that $3,000 minus a $250 deductible. So it's a nice coverage to have, especially if you have an injury. Who isn't insured under this policy? USRowing, obviously, their members, their member organizations, registered regattas, registered regatta committees, the officials, the coaches, and coaches, its employees, subcontractors, and volunteers are all considered to be insured coaches. Directors and officers, your managers, your volunteers. And again, keep in mind this is for, please excuse me 1/2 of a second. Very sorry, I forgot to turn off my phone. So this is for bodily injury and property damage coverages. General liability, again, as I said, is bodily injury and property damage to a third party caused by you or your club. The policy period runs from 12/31/2015 to 2016. And in order to renew your coverage, you have to renew your membership with USRowing, and that's generally tiers 1 through 6, and there's some tier 7s in there as well. But I think USRowing sends out, Susan, correct me if I'm wrong, but I think USRowing sends out reminders to renew your membership in December and January, plus we send out the brochure to remind you to do that, but you're not going to receive an invoice from USRowing so that you can pay for your membership. You need to go online and take care of that. I get that question a lot, like I didn't get an invoice. So I think the best way to talk about your insurance is to talk about claims that happen. These are things, a lot of these are claims that actually did happen over the years, and it gives you an idea of how your insurance applies. So a rower is struck with an oar by a teammate while rowing in a club practice. Provided both of the teammates are on the roster and have signed the online waiver, the club and the member who accidentally struck their teammate would have coverage under the general liability policy. If the member who was struck is also a championship member, there would be medical payment coverage under the excess medical policy. There is no medical payment coverage under the general liability policy for participants. It is for your volunteers and third parties only. So, the way this person would have coverage is if they sued their teammate because their injuries were substantial. The club and the person who hit the teammate with an oar would be covered under the general liability policy. Do you understand what I mean by that? Like, in other words, if a member got struck with an oar by another member and just had medical payments that they wanted picked up, that would not be picked up for a participant under the general liability policy. They would have to have the excess medical coverage in force. If you have questions about that, let me know. Okay, a rower is struck with an oar while participating in a registered regatta. When teams participate in a USRowing registered regatta, they are guaranteed that every club participating in that regatta is insured. We collect certificates of insurance from those clubs who don't use our insurance, and we know which clubs who do use our insurance. So we know that everyone who is at a USRowing registered regatta is insured, one way or the other. So depending on the circumstances, the person that got hit would have coverage either under the person who hit them's policy, which could be a U.S. Rowing policy, or under the policy that they have with another insurer. But we know that everyone there is insured. And again, if the person were a championship member, they'd have medical payments coverage under the excess medical. Two boats collide while participating in a registered regatta. One boat has damage, the other boat does not. And again, this goes back to, we know that everyone there is insured, but let's assume that both of these clubs have U.S. Rowing Insurance. The team or the person who caused the accident would submit the claim to their liability insurer, which would be U.S. Rowing, and that would pay for the damages to the other person's boat. It would not pay for the damages to the person who did the hitting. They would need to have an equipment policy in force. So it pays for the third party's damages, but not for your own damages. Two boats collide while participating in a registered regatta, but no one can determine who is really at fault. So an incident report is done, and, you know, it's like he said, she said kind of thing. It could be that, you know, no liability policy is going to respond, and each of the teams are going to be responsible for their own damages, and they should submit those damages to their equipment policy, which is why it's important to have your equipment insured. This has happened. We have had incidents where, you know, they couldn't really determine who caused the accident. It was kind of both, and neither insurer, one was a U.S. Rowing member, one was not. Neither insurer picked up the liability coverage, and both clubs were responsible for their own damages. A member slips and falls at your boathouse. The club would be protected under the general liability policy if the member sued and said they got injured because you had the conditions were unsafe. The club would be protected. There would be defense coverage for you, and if it was determined that, yes, in fact, it was your fault that the person slipped and fell, the policy would respond on behalf of the club. And again, if the member were a championship member and they had the excess medical coverage, or they were, you know, they had the excess medical policy, their medical bills would be picked up under that policy. A non-member slips and falls at your boathouse. Again, the club would be protected under the general liability policy. There's also $5,000 of medical expense coverage for the non-member. So if they just had some medical bills they wanted picked up, that would be picked up under the general liability policy up to $5,000. If they had more extensive injuries than that, most likely they would be suing the club, and the club would be protected under the liability policy. A shell being carried by the crew accidentally hits a vehicle and causes damage. The general liability policy would pay for the damages caused by the crew. A windstorm blows an unhitched trailer into a parked car. Same as above. The general liability will pay for the damages caused by the trailer. This is an unhitched trailer. So you have general liability insurance for your unhitched trailers that are sitting around by your boathouse. This does not apply when they're hitched. That's a whole nother scenario and has to do with your auto liability coverage. A member is storing their boat in your boathouse and it becomes damaged, but no one knows how. This would not be picked up under the general liability policy. The club is not responsible for damage to boats stored by others that was not caused by the club or a club member. If you're in the practice of letting people store their boats in your boathouse, or you're leasing space to people so they can store their boats, you should have a lease agreement in place indicating that you're not responsible for damages to that person's boat. Now, there's going to be instances where you've caused the damage in some way, and we're going to get into those next. The liability policy would respond. But as a general rule, you do not want to be responsible for people's boats while they're stored there. They should have their own equipment policy in place, and that's the policy that should respond if there's damage to their boat and no one can explain why. if you shut the garage door on their boat or something like that happens and you're responsible, the liability policy will pay for their damages. But if there's a fire, that's not your fault. It's an act of God. You're not responsible for those people's boats, and so you need to make sure they understand that. We did have this happen in the boathouse. The roof collapsed due to the weight of snow, and there were some boats damaged. The general liability carrier did not respond because the weight of snow is considered an act of God, and the members should have had their own coverage on their boat under an equipment policy. It went back and forth because, the member felt that the club should have known that their roof was going to collapse under this weight of snow, but it was one of those winters where we got a lot, and it was a lot of heavy snow, and the roof came down. So the liability carrier did not respond, and the member wasn't happy about it. And there was no type of lease agreement in place, so they didn't have an equipment policy, and their boat was damaged. So it was a problem. Now here's an instance where you could be liable. You have put racks up in your boathouse. Members are storing them there. The boat rack becomes loose from the wall and falls, and all the boats on the rack are damaged. In that instance, the liability carrier did pay. They felt that the club was responsible for making sure the rack was secure against the wall, and they didn't do their job, so therefore the liability carrier did respond and did pay for damages to those boats. We had another instance where the garage door got shut on somebody's boat, accidentally, and the liability policy did respond. Oh, by the way, if you need assistance with a lease agreement, I have sample lease agreements that you're welcome to, and I'm happy to forward them to you. I just want to say I'm not a lawyer, so you should probably have your attorney look at it, but it's just a standard, lease agreement saying that, you're leasing your boat there, that you had equipment coverage on it, or if you don't have equipment coverage, you understand that if it gets damaged through no fault of the clubs, they're aware that there's no coverage. Okay, an attendee at a regatta slips and falls on a dock. The host club is sued. Again, it's a registered regatta. The liability would respond on behalf of the club. We have this happen a lot at regattas. People fall, people trip, people, things happen. Generally, the carrier will try to figure out who was at fault. Did the person just trip over their own feet, or was there something there that made them trip and fall? Was there a hole that maybe, wasn't coned off or something to that nature? So depending on what happened, how the person fell, the liability will respond on behalf of the club. And they'll defend the club, until a judge might determine that it wasn't your fault and the person just fell over their own 2 feet, and therefore the club is not liable. But you do have that coverage there. An attendee, we had this happen, an attendee at a regatta falls on a sidewalk not maintained by the host club. So they rented, a park, and there was a sidewalk that kind of ran behind, the space where they were at. The club wasn't responsible for maintaining the sidewalk. Somebody tripped and fell. They sued the host club, but the general liability carrier defended the host club, but it was determined that it was the city's issue. They were the ones responsible to keep the sidewalks safe, and they had not. So we had given the city a certificate of insurance, naming them as an additional insured. But in this instance, we weren't responsible for maintaining the sidewalk, and the fault was not our fault. So the claim ended up going back to the city's carrier and not to the club's carrier. A tent being erected at a regatta blows over and damages a car roof. It depends on who is erecting it, but if it's a USRowing member, then the policy, the USRowing liability policy, responded and fixed the roof. If it was a vendor erecting a tent, then the vendor should be having their own coverage. When you have a regatta, you should be asking all your vendors for certificates of insurance so that if they cause damage, their policy will respond. Your USRowing policy will not protect a vendor that comes onto the property. They really do need to have their own insurance. So if you're having a registered regatta, you need to make sure that you are collecting certificates from all the vendors that are going to be at your event and making sure that they have insurance. We had this happen. An attendee at a regatta was bitten by a dog. The dog was brought by, a spectator. In fact, not even someone who was associated with any club, but just someone who happened to see some activity taking place down near the water and brought her dog, and then someone bent down to pet the dog. The dog bit this person, and they sued, the person who had the dog, but also the host organization of the regatta. The general liability policy responded on behalf of the host club, but ultimately it went to the homeowners insurance, and they were responsible for the damages. But again, your USRowing insurance is there to help you, even though it may not be your fault. So the policy responded and helped the club, but ultimately it was the homeowner's responsibility for taking care of their animal. This is just refs. The referees are covered for anything, that may happen. They're accused of favoritism. They're sued for not reporting an incident. They're sued for reporting an incident. Anything that might happen out there, we do protect the refs pretty well. There's not much they could do that wouldn't be covered under the general liability policy. In fact, I can't think of anything they would do. So if any of you out there are a referee, know that your general liability insurance with USRowing would respond on your behalf. And I know that all the refs are also championship members, so they also have the excess medical coverage. Okay, so at a regatta, there was a temporary racks put up by the host organization, and they invited anyone who wanted to put their boats there to go ahead and do it. That night, a storm came through, and it blew the racks over. The liability policy did not respond because the storm was an act of God and not the fault of the organizing committee. There was plenty of notice that the storm was coming through, and some chose to keep their boats on the racks and some didn't. But the policy did not respond for the damage to the boats. In that same instance, it's a temporary rack, and it just falls, maybe because it wasn't put together correctly. In that instance, the liability policy would respond for the damages because it was the fault of the host organization. For whatever reason, they didn't have it, they didn't put it together correctly. It wasn't anchored. Something happened, but, there wasn't any other outside influence like a storm that came through that caused the damage. The rack just collapsed. And so the liability policy did respond, and it did pick up the damage to those people's boats. Sexual abuse is included under your policy, so if there is an allegation of sexual abuse, it would protect the club, it would protect the coach. If it's determined that the incident was intentional, the coach would no longer have any coverage because we do not cover intentional acts under a liability policy, but there would continue to be coverage for the club in that instance. A coach is accused of causing physical harm for improper teaching techniques, or, they were doing weightlifting and something happened in the weightlifting. All of that is covered under the liability policy, and the liability policy would respond on behalf of the club and the coach for the injured party. All right, this is always a big one, is borrowing trucks. A club borrows their neighbor's truck to pull. Next time we do this, I'm going to have a quiz. I'm going to make you guys answer whether you think this stuff is insured or not. A club borrows their neighbor's truck to pull a club trailer. The hired non-owned auto liability coverage would not respond. It's the neighbor's policy that will respond, unfortunately. If the neighbor's limits were exhausted because it was a really bad accident, the USRowing hired non-owned auto would protect the club, but it would not protect the neighbor. So it's really the neighbor's insurance that applies first, and then the USRowing policy would come in second, but only to protect the club. So you need to make sure the people that you're borrowing boats from or trucks from are aware that, their policy is going to respond, not the USRowing policy. If you rent a vehicle, like from an enterprise or wherever, the higher non-owned auto liability applies. We don't have any age restrictions on our policy, so you have liability coverage for that rented vehicle. The coach uses his own vehicle to pull a club trailer, the same thing. It's going to be the coach's policy that responds, and the USRowing hired non-owned auto liability will respond on behalf of, Deb, I'll get to you on that. That gets convoluted, but yes. The coach's policy would respond first, and the USRowing policy would respond on behalf of the club, but not on behalf of the coach. You can rent from a neighbor, okay? And I have, again, a sample rental agreement where you're renting a vehicle from your neighbor, and you're agreeing that you'll insure it, and there's an actual lease agreement in place between the two parties saying we're going to rent it for the weekend or whatever the time period is. The caveat to that is the neighbor cannot be the driver. So you are renting that vehicle without that person driving. And the reason being, once you rent a vehicle with a driver, it now goes back to the neighbor's insurance coverage. So if you're going to do that, the first thing is you have to have a rental agreement in place, and the second thing is the owner of the vehicle cannot be the driver. Now, some clubs I know will borrow from, say, an enterprise because they know somebody's father's mother who has, a connection at enterprise, or maybe a school's van they'll be allowed to use. The same thing, make sure that you have some kind of lease agreement in place with that party, and make sure the owner is not the driver. And then you're okay. The liability policy will apply. Now, that's liability only. If you damage that person's vehicle, there's another coverage that you can buy, but it's not automatically included. The only thing that's automatically included is the liability insurance, meaning if you hit somebody else in that vehicle, the policy will pay to have that other person's vehicle fixed, but not your neighbor's. Your neighbor's pulling a club trailer, hits another vehicle, again, it's the neighbor's policy. A rented vehicle is damaged while parked at a regatta. This is not covered under your hired non-owned auto liability. You would need to purchase hired physical damage, or another term for it is collision insurance. You can get that through your rental car company, or you can get it through my office. We put an annual policy into place. It's $227 for a $50,000 limit, and it runs it runs concurrent with the USRowing coverage of 1231 to 1231, and you have physical damage coverage for every vehicle that you rent. If you rent once or twice a year, it makes sense to take it from your rental car company. If you do a lot of renting, say in the spring season or the fall season, you may want to purchase that coverage through us. And then we can provide you with a certificate of insurance showing both the liability and the physical damage coverage. You can also add this for your neighbor's vehicle that you are leasing. Again, the owner can't be the driver, but now you've got liability coverage on your neighbor's vehicle, and you've got physical damage coverage on your neighbor's vehicle. There's a $100 comprehensive deductible and a $1,000 collision deductible. Do you know the collision is, you've hit someone, so there's damage to the vehicle, and you would have to pay the $1,000 deductible. Comprehensive is when, like, a rock hits the windshield, or there's a dent in the door and you don't know how it happened, maybe while it was parked at a regatta. That is comprehensive, and you have to pay the $100 deductible. A rented vehicle causes damage to another vehicle. Again, the liability is going to pay to have that other vehicle fixed. If you purchase the higher physical damage, then that would pay to have the rental car fixed. A rented vehicle is pulling a club trailer, so we know it has liability. A boat strap breaks. The boat falls from the trailer, causing damage to a vehicle behind it. The auto liability would pay to have that vehicle behind you fixed. But the boat is damaged. This is not covered. There should be an equipment policy in place for your equipment. This has to do with the excess medical policy. I think you've heard me talk about this enough, but if you're a championship member and you have some out-of-pocket expenses as a result of a rowing-related injury, this policy will sit above your primary medical coverage, making you'd only be out of pocket $250. There's also a life insurance component to it. It's $15,000. It's not a lot of money, but I know it's some for your family anyway to help with expenses. But again, you need to be a championship member to take advantage of those coverages. Dental is also picked up under that excess medical. We had someone who had some dental issues, but he was not rowing when it happened. The policy does not apply if it's a non-rowing related activity. They would have to have been participating in a rowing related activity for the excess medical to apply. It also doesn't apply to like eyeglasses. So if they're out there and if they're out in the water and the eyeglasses fall into the water and they lose them, it does not apply to eyewear. If you had an eye injury, it would pay for the eye injury, but not things like your eyeglasses. That's not picked up under this policy. Okay, and then I'm going to give my speech about waivers, which I always hammer. Make sure you have people signing either their paper waiver or their online waiver. The paper waivers are only for Learn to Row events. You really shouldn't be collecting paper waivers for your regular members. They should be on your online roster, and they should be signing the online waiver. And the first thing Philadelphia Insurance Company or any insurance company that we put this coverage with is going to ask is, did they sign a waiver? You do not want to get yourself caught that you don't have a waiver for these people. It's really important that you get this done. I know people don't like it, and but it's imperative to the insurance coverage. So be careful with that. So I don't really have a whole lot else. Those were some claims examples. Does anyone have any questions? Do you have any examples? Do you have any anything with respect to your club that you'd like me to address? The same as it works for your employed coaches. The general liability is in place, and so if they're a volunteer, by definition they are covered under the general liability policy. Now, are you talking about excess medical, Jeff, or just the liability coverage? And yes, we do have directors and officers liability insurance. And that, I can, if you send me an email, I can forward you over the application. It's a very simple application. It's one page. If you buy a $380 or a $1 million limit, it's $380. A $2 million limit is $770. And then there's a crime component that you can add to that. It's easy. Do coaches need to sign the USRowing waiver? We've gone back and forth with this. There's some employed coaches that don't want to sign a waiver because they feel like they're signing away their workers' comp rights. I encourage the coaches to sign a waiver, but if you have some that don't want to sign a waiver for whatever reason, I think they think they're giving up their liability insurance in some way, and that's not the purpose of it, but that's how they feel. So we ask that they do sign a waiver, but not all of them will. So for your volunteer coaches, Jeff, if they're championship members, they have liability insurance and they have excess medical coverage, and they're good. I don't really know that there's anything else you need to do for them. Championship membership is key for those people.
A small regatta or regatta that does not need to be registered in this case is a regatta that has 2 or 3 clubs participating. So once you have more than that, so once, say, a small regatta has 4 teams or more, in order to have the coverage for the event, you have to register it, including the coverage for your referees.
Coverage automatically for dual and tri events, but once you have over 3 teams, you have to register the regatta, and everyone has to sign a waiver.
Also just put the link in the chat window in regards to the 2015 member brochure. We're getting ready to create the, I'm sorry, 2016. We're getting ready to start working on the 2017, but any of the details in terms of coverage, we've got frequently asked questions on, common questions. All of that can be found online in the digital version of the member brochure, and I've included that link within the chat window.
Okay, Jeff, so you're leasing space to a USRowing member organization. They, in turn, are letting third parties store their personal boats in the lease portion of the boathouse. There should be lease agreements in place between yourself and the USRowing organization, and then there should be lease agreements between the other USRowing organization and the other people that they're allowing. I don't know that you need one between yourself and the third party. You're kind of, the middle person there is the other USRowing organization, but there should be lease agreements in place, that they know they're leasing space, they know if it gets damaged, you're not responsible, that kind of stuff. I wouldn't go without the lease agreements, and like I said, I can provide you with samples, and I would encourage the people that you're leasing to have the people that they're leasing to sign a lease agreement. Jeff, summer program participants, they should be on your roster and they should be signing an online waiver.
Jeff, also in addition, with a tier 6, usually the requirement is, for all members of the team to be a championship member. And I don't know how long your summer program takes, but we usually, if something is a learn to row program, and people are coming once or twice to your boathouse just for like a summer thing to try out rowing, and that's the only thing they're doing, then they don't need, they can just sign a paper waiver as long as it's learn to row. But if you are a tier 6 team and you want to cover people who are visiting your team for a longer period of time or who are spending a couple weeks at your club, then the membership requirement is a championship membership because you are tier 6. Like, that is considered a membership because they're spending an extended period of time with your team.
That's right. So, Jeff, I would say if they're only coming for 1 week, the paper waiver would be sufficient. If they're coming for any longer than that, it's no longer learn to row, and it's a summer camp, and you would have to, because you're tier 6, make them become members, make them have the championship membership, which would cost them either $45 or $65, and then put them on your roster. Your membership dues doesn't change with the number of people you have. So it would just be asking those people who might be coming for longer than a week to become a championship member. But if it's a week, I would say paper is fine because we would consider that learn to row.
As for Deb's question, if the number, a part of the issue with the compliance for registered regattas is that the number of clubs and participants and parties that end up being involved as, possible parties that could be liable for something. The rule is that if there are 4 teams or more attending your event, and it's, depending on the number of people, like in total, but particularly about the number of teams, they have to all be USRowing organizational members, all the different teams, and you do have to register the event. Chelsea, I have a follow-up for your question. Is who covered with championship membership? Because if the question is, like, if you are a tier 1 through tier 5 team, so you cover an X amount of people for your club, then the coverage applies to those people as long as it's a club sanctioned activity like a practice or going to an event. Then the coverage applies when those people are basic members. The championship membership just provides additional medical coverage for the individual, which in this case, provides them with the medical insurance if something happens for which not necessarily someone else is to blame. So if there is no liability on your, if there's no liability for your team because of what happened, but they have, a medical episode or, something of that nature happens, then they are covered as champ members, but not just as basic. So that's the difference between the liability coverage that's tier 1 through tier 6 and, the coverage that applies to a champ member alone.
Right. I did do it verbally, and the directors and officers insurance is available. It's $380 for $1 million of coverage and $770 for $2 million of coverage, and it's a one-page application. Send me an email and I'll send you over the application. Also, if you have my thoughts for the next session is certificates of insurance. Because a lot of you asked me for them, and I don't know that you'll understand why you're asking me for them. And also the auto, because that's always a big issue with people who are borrowing vehicles, renting vehicles, thinking of buying a vehicle. It's a hot topic I get a lot of questions about. But if you have any suggestions or anything you would like to hear more about, please let me know. We have the Directors and Officers program. Many of you already participate in that, but maybe you'd like some more details about that coverage. So please, forward your suggestions so we can put together something that's of interest to membership, more than just this basic, what you get with your USRowing insurance. I'm happy to address any topics or, questions or whatever it is that you'd like to see us present.